Assalamu alaikum and welcome to a brand new show, Just Law, with your host Nasreen Kareem. And we have an incredible show lined up for you. We'll be focusing on a crucial topic that many of us often overlook, such as wills and probate services, divorce, child contact, properties, litigation. Whether you're thinking about creating a will or wondering how to navigate the probate process or have questions about property transactions, we've got you covered. On today's programme, we'll be discussing what happens to children when couples separate or divorce. Now, whether you're watching us live on ICRA TV, Sky 739, or whether on ICRA.tv via the website, if you have any questions or need assistance, please don't hesitate to ring our live number at 01274 214 299. I'll be more than happy to help you out. And if you'd prefer to share your story without being on air, that's absolutely fine too. You can get my contact details from the control room. Now, as I've mentioned, today's topic is going to be what happens to children when couples divorce or separate. Now, this is something that comes up all the time. I've been a practicing solicitor for 25 years, and when I first started my career, I wanted to be a family lawyer, and then I've evolved into other areas. But one of the areas of law that has never left me, which I feel so passionate about, is divorce, child contact, and generally family matters or matrimonial matters, as we refer to them. Now, over the years, we've been dealing with child contact, dealing with fathers or with mothers. And one thing that always comes up is there is a tug of war over children, and sometimes parents feel the need to deprive the absent parent of contact with that child. And one of the things that I always say to my clients, whether it's the mother or a father, it doesn't matter what's happening between mother and father, you have to think about your children. And if your child or children wants to see the absent parent, then as a parent, you have that obligation to make sure that contact takes place. Now, I've had instances where children haven't wanted to meet their parents, which is fine. When a child reaches 10, 11, 12 years old, the court will always ask the child whether he or she wants to meet his or her father or mother sometimes. When children are a little bit younger than that, then the court instructs what we call a CAFCAS officer, and the CAFCAS officer will have an interview almost, sometimes with the child, but most definitely with either parent. So how do you find yourself in this position? You're married, or you've been living together, whatever the circumstances are. You've had your garden, but maybe not legally registered your marriage. That marriage falls apart, and more often than not, the innocent party is generally the children. I have fathers who come to see me to say that they want to see their children, but mother won't allow it. I sometimes, but not so often, get mothers who will come to see me to say they want to see the children, but for some reason the father has custody of the children. So what happens in those circumstances? I always say to both sets of parents, whether it's mother or father, please do what you can between yourselves to try to arrange contact for yourself with the other parent for children. Because when solicitors get involved, it becomes a little bit more difficult, but that's when the other parent will be offended and sometimes will say the solicitors are involved. So what I always do is recommend to my client, please, first of all, contact your partner and ask him or her to arrange contact privately. So that is always my first port of call. Sometimes in this country, some parents are told that they will never see the children again. That is simply not true. Whoever the parent is, whether it's the mother or the father, one of the rules of this country is that whatever the circumstance, unless there is domestic violence or safeguarding issues, the court always encourages the absent parent to have contact with their children. Now, when a person comes to see me, I will say, go away and please sort out contact arrangements between yourselves. If that fails, I will then write to the other parent and say, I'm acting for whoever the parent is, and we would like to see the children. We will normally list the children, we normally have the dates of birth, and we will ask the other parent in a non-aggressive manner if that parent can see that child. Sometimes we get a response, sometimes we don't, and what happens is we will have to keep writing to that parent. But if it looks as though that parent is under no circumstance going to allow contact between the absent parent and the children, we then have to make a court application. Now, this in itself can be quite stressful for all parties concerned, because once it's left the remit of the parents to resolve between themselves, you have another body that is going to intervene and take control and take charge of what is going to happen. And I always... Hi, Assalamu alaikum, do we have a call?
Walaikum salam, this is Iqbal here. How are you?
I'm very well, thank you. How are you?
Not too bad, not too bad. Nice to see you on the screen again.
Thank you.
This is Iqbal. You're looking confused. This is Iqbal Bana here. I've had a question somebody's asked me. It's not related to the subject you're talking about today, which is about family issues, but I hope you might be able to help me with it.
Okay.
An old lady has passed away. She had no children. So she left her property to her nieces and nephews. When she passed away about 2-3 years ago, the property was valued at about 70 to 80,000 pounds. The nephews and nieces have now decided they want to sell the property. It's now valued at 100,000 pounds. The probate and everything has been granted. The question was, is there any inheritance tax or capital gains tax to be paid? And I know you are quite an expert in property law as well. An Italian lady who passed away, a friend of mine, his friend, she was quite old, she was quite ill. As I said, she had no children whatsoever. So she passed the property, the inheritors were her nephews and nieces. So the question now is, they want to sell the property after about 3 years, and is there any capital gains or inheritance tax issues?
Okay, so number one, there is absolutely no issue with anybody leaving anything to anybody. Number two, I'm glad that probate's been granted, because one of the delaying factors in all of these types of transactions is that it takes so long to get probate. So I'm glad that's been done. Number three, I am a solicitor and not an accountant. So as far as capital gains tax or inheritance tax goes, I can't advise, because all those things will be based on the parties involved in the transaction. So capital gains tax is applied where there's a property, there's been a gain on it. So for example, in this case, the value of the property has gone up, and a percentage of that would be liable to capital gains tax. I don't know the answer to that because I'm not an accountant, but if they go to an accountant, they will be able to help with that. But as far as the probate process goes, once they have a buyer for the property, we as property lawyers, we can deal with the transaction, but one of the most important documents that we must have is the letters of administration or the grant of probate, because without that, legal title cannot pass to the new buyers. So I can't fully answer your question, but I can partially answer your question in that they must go see the accountant to establish what the tax liabilities are. But from a solicitor's point of view, yes, it's something that can be done and is done frequently.
I've been told that they've sought the advice of an accountant, they've seen somebody, and the accountant said that as the property is not above the £320,000, £220,000 threshold, there's no liability for capital or inheritance tax. So I don't know how accurate that is.
So there is a £325,000 limit, but that applies to all the assets of the person who's passed away. So again, need to establish what exactly was in the pot when that person passed away to decipher whether there's any inheritance tax or not. And then again, we need to establish whether there were any exemptions or any allowances for that person to try to calculate what capital gains tax was. But it's an accountant's question, and I'm not an accountant, but more than happy to talk about this afterwards. But thank you for your question, though.
I will pass them on to you and to the accountant as well. Okay.
Thank you.
Thank you very much. Doing a wonderful job. Take care.
Thank you. Walaikum salam. So if you have any questions of any nature, please call us and I will try my best to answer your questions. Sometimes I will be able to answer them, sometimes I will not. but I can speak to you off air as well, and we can discuss any topic that you have any queries with. Now, going back to my previous topic, child contact. So I was saying that if a parent comes to me, and we will write to the parent that has care of the children, and if that parent doesn't agree to any sort of contact arrangements, then we will then need to go ahead and make a court application. Now, the court application is a long-winded process, and again, I advise my clients that it's going to be costly. Please try to arrange something between yourselves, and we'll try to use this as the last resort. So the court application consists of a C100 application form. The application fee is just under £600. Now, if you're on a low income, then you may be eligible for help with the fees, but that comes under legal aid. As a firm, we don't do any legal aid, so I can't advise on that. So my clients will have to pay the court's application fee, fill in the C100 application, and that application consists of details of both parties, where the children are living, which school they go to, have there been any safeguarding issues, have social services been involved, have there been any previous orders, full names, addresses, dates of birth. So that can take a little bit of time to actually fill in and complete. And at this time, again, I will say to my client, please try to arrange something between yourself and your partner. Sometimes at this stage, I will again write to the other party and say, please, we're going to make a court application. This is going to get costly, not just for my client, but for your client, and also the court is going to be involved. CAFCAS officers will be involved, the judge will be involved, and this is going to be taken out of your hand. So if you want to make some arrangements, please do so now. Now, child contact can take place in so many different forms. It can be seeing the children in a contact centre, for example, where the parents cannot agree on a location and there may be some safeguarding issues. Sometimes there aren't, but sometimes there are. So contact can take place in a child contact centre. But more often than not, it's a case of the absent parent picking up the child from mum or dad, spending a few hours with them. Sometimes contact can be overnight. Sometimes contact can be after school for a few days. Sometimes it can be at the weekend. It is entirely up to you, up to the other partner, to decide what form that contact should take place. And also the child as well. If the child is over the age of 10, 11, he may say, or she may say, I don't want to go and spend the weekend with my father. I have clubs, or I have friends to see. Whatever it is, the form of contact should be what all parties can agree to, rather than trying to be aggressive and trying to force contact on anybody. And always, if you're the absent parent, speak to your son or daughter, or sons or daughters, and ask them how they feel, and ask them if they want to have contact and what form of contact do they want to have. If you have them for a few hours, where do you want to take them? Where do they want to go? So the whole point of contact is to continue that parent-child relationship. It shouldn't be aggressive. It shouldn't be about the person trying to win one over on the other party, because that sometimes happens and it's really sad to see. It should be establishing and maintaining the bond between parent and child. Now, if we've submitted our C100 application to court, then the court will then issue that, and they will send us a copy, or we can ask the court to serve it directly on the other party, who's now going to be named as the respondent. My client will be the applicant, the other party is the respondent, and there will be court directions to follow. And again, it can be quite invasive for parties, especially if you haven't been in that system before, where you are having to answer to the court and to other parties. For example, if I'm going to be writing to the respondent, I will be asking for more information. What school does the child go to? I want access to school records. I want access to GP records. I want to know how the child is doing. I want to know what the health and well-being and mental well-being of that child is. Is that child suffering anything? If the parents have separated, that can have such a huge impact on that child and who is there looking after that child's mental well-being. These are all the factors that the court will consider. So there remit in all of this is the child. They're not bothered about you or your partner or what's going on, or if there's a divorce and he wants X amount of pounds and you're not willing to give that much money, or there's a dispute of contents in the house, or things have been left behind in the house and there is an argument between the couples. The court does not care and is not interested. The emotional, mental and physical well-being of that child or children is what is important. Please bear that in mind. Now, once the respondent receives a court order, there will be a hearing date. And we will say to the respondent, please get legal representation, because when we have parents who are not instructed, who do not instruct a solicitor, the process can be a little bit more difficult in that they don't quite know what they should be doing, how they should be dealing with court documents, what they should be telling the court. And at the end of the day, we just want something that's going to be simple and easily achievable for all parties. Nobody wants to be in the court system for 12 months. I've had child contact cases where they've been in the court system for 18 months, 2 years where parties don't turn up to court. Child contact's been arranged and the children haven't been made available. There are excuses filed, and all this does is aggravate the situation. And instead of making sure that the child has his or her parent to form a relationship with, all that it does is antagonise the parents, and it really becomes a tug-of-war game. And this is something that we as solicitors really have a duty to avoid. And even though we're instructed, and you may think, well, we get paid for this and the longer it goes on, the better. Well, no, not really. What we want to do is make sure that the child is looked after, that things are running smoothly for all parties. Nobody wants to drag people into court, and nobody wants to make things more difficult as it is. I've had so many couples that have gone to court. They're in the waiting room, they're not speaking to each other. One of them thinks that this is just a ploy by the other party just to make them suffer. It really isn't. I'm not going to lie, sometimes it can be, because sometimes it can be used as a tool of power, but really, and I always repeat this, try to arrange contact between yourselves, because once it's taken out of your hand, it's out of your control, and you may find yourself in a position where the judge takes control. Now, I hope you're enjoying the show so far. We're going to take a quick break, so don't go anywhere. Grab a drink, stretch those legs, and we will be back to you in just a few minutes, where we will carry on this conversation about child contact.